It's not just a start and stop.
No, it's okay.
Thank you. All right, good morning, and we are going to talk today about the summary of changes that happened on the contract of purchase for Cincinnati. Ask questions, and if you have questions, please, and we'll go through this together and hit the hot points that have changed. So, William, thank you again for being here. You always are. I appreciate it. Jeff, thank you for coming as well. So we're going to start with, did I give you the change sheet, right? Okay, cool. Okay, so we're going to start with the changes that have actually happened and go through the sections of that have actually made the changes. So section 3 is the first change that has happened. And that is talking only in one section, and that's talking about the earnest money, and 3-day default has been removed. So they removed the 3-day default if their time frame is specified. So you have to put in your own time frame. Let's see. Yes, within blank calendar days. You already have it highlighted. Thank you for that. I'm not working from my highlighted copy. That's great. So on page 1, section 3, line number 14, then you would write in the calendar days that you want the earnest money to be put into an escrow account. Now, normally, I like 3 days. I think that gives them plenty of time to get their money in, unless there are some extenuating circumstances. So if they just can't get to the earnest money for whatever reason, then maybe you take it to 5 days. I would not put an extended period of time in there, though, because it has the ability to cause issues with your contract as time goes on if you don't have the earnest money in hand. So make sure that you do that. The next section that has been changed is section 5, which is the section on appraisal. So let's move down to section 5. There we go. So section 5 with the appraisal added D after reference to section 4 for clarity. So thank you for your assistance. I appreciate it. Basically what they've done here, let's start reading on line. You know what? Let's just read that whole paragraph. Can you read that for us, William? So you're so good at this. Thank you so much. I appreciate it.
The buyer's obligation to close the transaction contingent upon the real estate appraisal and/or a final sales price of the real estate. Buyer has the right to obtain a buyer's expense. Appraisal performed by an appraiser licensed in Ohio. In the event the real estate does not obtain an appraised value, buyer's appraiser in connection with sale funded by cash or other funding source or lender's appraiser with the finance sale or everything equal to or greater than the purchase price. Buyers have the option to terminate this contract to complete seller the language and appraisal the cash funding source the day following the contract date or 2. FHA, the USDA, or VA financing, the time set forth in section 4E above for obtaining a loan. So the applicable time period being referred to as the appraisal change. The buyer does not produce a written notice to seller that buyer prior to the appraisal of the appraisal contingency period. The buyer's option to terminate the appraised value.
Okay, so what do you think that means in normal terms?
Basically, if it doesn't appraise, they terminate the contract, but they have to let them know so many calendar days.
Exactly. So, and if they don't abide by that, then they're saying they're going to go ahead with the contract and accept it at the appraised value. There's a lot of problems with that, the way I think that that is written, but it does coincide with financing terms as well. So, whenever you're looking at this above four, let's look at 4D. The time frame is that section of 4D above for obtaining a loan approval, such applicable time period being referred to as the appraisal contingency period. So what they're saying is that the loan approval time is the appraisal contingency period. That changes typically only if it's going to be a cash buy that you decide to do an appraisal on, et cetera, that kind of thing. Now, we all know that when an appraisal doesn't come in, one of three things is going to happen, right? One is what?
It's good.
They can terminate it, or
They can go over, they can just,
if it doesn't appraise to full value, buyer can pay the difference. Yep, exactly. So one of those three things would happen. So just make sure that in all of your times that you follow those timelines exactly. Whenever you do a contract that is accepted, the first thing you should do is write out those timelines to know exactly when everything is due.
So how many days? Well, if the buyer comes to the appraiser, so they don't really have to like come back to us on the day, like, let's say they get the appraisal back on Tuesday.
Well, what they're saying, they're in 96, in the event of purchase would be a cash or other funding source within blank calendar days, beginning the day following the acceptance date. So that is cash or other financing. Now, if you're following along with your regular financing, let's say it's FHA, VA, conventional, the time period is going to follow that. Okay, it's going to follow whatever's there. So that time that you're going to put in is going to be whatever's going to cover just cash or other financing. So other financing could be hard money financing if they decide to do like something, or trying to think of another instance where that might come into play. Where if it were cash and you were still going to be doing appraisal, anybody can do an appraisal on any property that they're purchasing as long as it's written as a contingency. So just be careful with that to make sure that, because they're kind of, they really are unrelated.
Four D is basically saying that they have to bill so many days prior to the day of the close. Some of them just open the door to the week of.
4D above, for obtaining a loan approved, such applicable time period being referred to as the appraisal contingency period. If buyer does not deliver within notice to seller, then they can terminate the contract. But basically what that's saying is in 4D above, for financing a loan approval, such applicable time period being referred to as the appraisal contingency period. So that loan approval time and the contingency for the appraisal are they're side by side. They're exactly the same. But if you're not using that, if you're not doing financing, and you're doing cash or some other funding source, that's when that other date would come into play. And that's when you would put X number of days in there. I'd probably use 21 days, probably. A minimum of 14, probably up to 21. Because when you're doing an independent appraisal, sometimes it's harder to get an appraiser out there than it is if a lender's ordering one. A lender.
The lender's going to like enforce that it'll say it comes in low. The lender's going to like, they're not going to wait for low. You're going to be there. They're going to know right away.
As soon as I get the appraisal, yeah.
As soon as you get the appraisal, so that's not, it's not really like pertaining to like finding, like if it comes back FHA loan comes back low.
Yeah.
Then,
well, it goes back to the same thing. Typically what happens with that in that instance is most FHA buyers are not going to have cash to bring to closing. So what is going to happen is you're going to go back to the seller and say it didn't appraise. They're not going to be able to bring the money to closing, so you need to lower the sales price.
exactly.
So that's typically what would happen in a case like that. Yeah, I mean, in some instances, there may be an appraisal gap written into an
Yeah.
offer where they
We
would
did that.
automatically bring the money. That's typically not like with an FHA, VA, or anything like that. They're just not going to be doing that typically. I mean, they may have money, and mom and dad, or somebody, one of the relatives may say, "Yeah, we'll give you a gift to cover that." But it's a little more difficult when you're getting involved in those situations. So you think we got that? Okay. Now, section 6 is the next, and that's inclusions and exclusions. So let's go down to section 6, which is right here. And in section 6, the only thing that they have really changed is they added hot tub to standard property inclusions. So now, whenever you're writing the contract of purchase, which we're talking about today, and sorry, and also looking at that from the selling standpoint, if you're listing the contract, also note to your sellers now that the hot tub is an automatic inclusion. Okay, so on the other side, on the buyer side, though, it is also an automatic inclusion. So if they don't want it to stay, this is where they would ask it to, as an exclusion, to be removed, and that would go into um, sorry. I apologize, you guys. A lot of agents are having closings today. Therefore, we're having a lot of calls and problems. Just do this. Okay, you're correct. It's 6B is the following items are specifically excluded from the real estate. We generally don't have a lot of things that we write in there typically, but there are things that we might not want to stay, and that's where we would write them in. And that would be if you don't want that hot tub to stay or anything else that's in the list above in section 6, that's where it would be written. However, go back to 6A and the following items which add no additional value to the real estate are specifically included with the real estate. And that would include anything not listed above. Now, if there's anything that I think is a little precarious, that might be questionable, I would always still write it in as an inclusion there. And I would also write it in as an exclusion if I didn't want it to stay in section B. Remember that just because an MLS listing offers something, if you don't, let's say that it's offering all appliances, but you don't identify in here that you want to include this appliances, this automatically does in section 6. But if there's something that is listed, but you do not make sure that it's in section A, section 6, or included in section A, then they can take it with them, if you don't have it in this contract, because this dominates everything else that's been written. This takes the place of anything that was on MLS. So make sure that anything that is in MLS is reflected here in section 6A, 6B, well, 6A and 6B.
What about rain? That are already at like the door?
Um,
I think a lot of people take it, but they're already at the door.
yeah, there is a place that does reflect that.
Okay.
So, yeah, I believe that is, we'd have to go through here and look at every single one of those. I'm sorry.
It's happening a lot. Right? People want to wait cans.
Yeah, it is. It's happening. So, just to be clear, did you find it?
Doorbells and chimes and put on all fixed, so there is a lot of those security alarms.
Yeah, so it's already listed here. I don't believe that it's listed in Kentucky though. So if we're talking about, I ran into that a few months ago on a property. They had a very expensive security system. They did not want to leave it, and we stated such that the buyers really wanted it. So I don't really remember how that played out, but the sellers did not want to leave it, the buyers wanted it. So especially in Kentucky, you need to be careful with that. But this is specifically Ohio that we're looking at right now. Most of the people that, oh, no worries. But whenever people hop into here to look for the changes, that's not a change. I mean, that's been there for a minute, but also, I'm a little overkill on asking for things to stay. So Jeff, like you, if it's not even listed, or if it is listed in here, I'd probably go ahead and add it anyway. Anything that's a little different that people aren't used to leaving, that they think they should be able to take, such as cameras, I'd probably write in separate. Any questions on that? William, you've been through this. You could be teaching this. You're doing a great job with it. Thank you. Okay, so in the next section, it's what we've been dealing with since last August, and it's the terms of broker compensation. And under broker compensation, they've added a statement, nothing in this section supersedes any existing agreements. Nothing in this section supersedes any existing agreements. So they also moved the clarification about blanks in 7C, 7D before compensation amounts in this section. They also changed option added for buyer to indicate if they are self-represented. So that's new. That's brand new that they've added that in there. And if it's a self-represented buyer, then you'll just have to see how that's going to work out whenever you're talking to them. Changed or to and in 7C and 7I. The new sentence, if the amount that seller agrees to pay herein is less than what buyer owes under the buyer representation agreement, then buyer shall be responsible for the remaining balance. And so they have added that the buyer is responsible for any remaining balance. Now, does that have to be upheld? That's questionable. There's still a lot of questions out about how these broker compensations are paid, are being paid, are being adjusted, not adjusted. So I would take these on a case-by-case basis, but if we are following exactly what this contract says, and the contract does say the buyer is obligated to pay the difference, period, that's it. It doesn't give you any other instances here. So whenever we're looking at terms of broker compensation, broker fees and commissions are not set by law, are fully negotiable, and may be paid by the seller, the broker, the landlord, the tenant, or a third party, or by sharing or splitting the fees and commissions between brokers. Nothing in this section shall amend or supersede the total amount of compensation due the brokerage under any other representation or compensation agreements. If any blanks in subsection 7C and or 7D below are not filled in, it shall be construed as zero. Be very careful when you're writing this contract, this offer, that you make sure that you put your compensation in here that you're asking the seller to pay for you. If you don't do that, it says it is construed as zero. And good luck going back and changing this after you have an accepted offer.
So, correct, but it's like, so let's say you put in 3% and during negotiations, you come back. So, 2%. Right?
Mm-hmm.
So I have agreement with the buyer to pay 3%.
Correct.
So our brokerage going to hold us our fee to the buyer to get the other 1%.
We aren't going to hold your feet to the fire, but if we're following exactly what this contract says, it says that they have to pay it.
Yeah.
So are we going to hold your feet to the fire? No. But how is that going to play out later? We don't know. These are still uncharted territories. So we're still dealing with, things that are happening in the industry. And do we have to get that money from the buyer? We haven't been necessarily enforcing that. But at some point, if it goes to court and goes into litigation and somebody says, no, they have to pay it because it says, then that's another whole story again. So I think it's just questions. And we've said all along since last August, and Jeff, you were here, that we're going to have more questions than answers throughout this process, and it is still continually changing. Huh?
I didn't know what the brokerage standpoint was on that.
I mean, we negotiate our deals, but here's the thing. Whenever you do your negotiation with your buyer, it should be a sit down where you go over everything with them, explain to them the process and see where they are process wise and what they can pay. Maybe they can't pay anything. Then you may have a problem on the other side. But most of the time we will be asking for commissions from the seller. But again, they're all negotiable. It's up to buyer and seller. It can be split, it can be not split. So we read exactly what it says here.
So would it be better if I got an addendum?
At some point after the transaction,
Well, not, yeah, I mean, like, at the time of, like when you negotiate the deal, and they come back and they want, only the seller wants to pay 2%. Do I just write that? Seller wants to pay 2% to cover myself, you know what I mean?
well, they're going to come back with a counter offer on the contract because that's where you're asking for, yeah, that's where you're asking for the money.
The seller wants to pay 2%. Or 2.5%.
Well, they're going to come back
Yeah. That's what
on this off, you're talking about the contract of purchase that
Yeah,
we're
the
discussing
contract
right now.
purchase, yeah.
Okay, so if you ask for 3% and they're not accepting it, they're going to put that into the counter offer that comes back to you. So they're going to strike through that and put in the 2.5%.
And that would cover.
And that, then everyone initials that and that will cover that piece. No. No, not necessarily, because what it says here is, It- no, nothing in this section shall amend or supersede the total amount of compensation due the brokerage under any other representation or compensation agreements. If any blanks and subs, then we go on then that would be zero. But yes, no, it does not supersede it. So whatever is agreed upon in this contract is what is basically agreed upon. Okay, and that also states that it does not supersede any other prior agreements. So theoretically, what they're saying here is if you've signed a 3% buyer broker agreement commission being paid by the buyer up to, they're saying that you need to go after that money. And that language is not in there. That is brand new. That's what it says. Would it be upheld in court? I don't know. I'm not a lawyer and I'm not a judge, so I don't know. The only way we really figure these things out is when the controversies come up and how they play out, unfortunately. I wish I had better answers for you there.
I just want clarity. I just want clarity.
Let's see. So
No.
yeah, we're going to that, but just a second here. So we didn't get into two, did we? Buyer shall pay all remaining buyer brokerage fees. We did not talk about that yet. So in line 150, buyer shall pay all remaining buyer's brokerage fees, if any, due from buyer under the buyer representation agreement, i.e. buyer's brokerage fees due under the buyer representation agreement, less amounts agreed to be paid by closing at closing by seller. So again, it's reiterating exactly what we just talked about. It's not superseding that agreement, and this is saying that the buyer is going to pay that difference. It's not giving them an out here. So it's saying that if you're signing a 3% and seller's only paying 2%, then the buyer is going to be responsible for that 1%. I know it's not exactly what we've dealt with in the past, but other terms for payment of compensation, and
Is this where we write our like $3.99 in there?
yes, because we do charge $3.99 as a fee for the office, so that that's where you would put that. Okay, let's go to line 156. Notwithstanding the foregoing, buyer acknowledges that any amount that seller agrees to pay to buyer's brokerage at closing shall not exceed the total amount the buyer owes to buyer brokerage under the buyer representation agreement. So you have to put your amount in there. So if you put only 2% to protect your buyer and they come back and are paying 3%, you're losing 1%. You can't get that money. So, right? So that's exactly what that is saying.
It's
So
like a double-edged sword. I mean, you can't go low because you won't get the money. You can't go high because they're going off for the remaining money.
I know it is. It totally is. So, let's see, and agrees that if the amount on line 158, seller agrees to pay herein is more than what buyer covers under the buyer representation agreement, seller's payment to buyer's brokerage shall be adjusted to match buyer's actual obligation, and if the amount that seller agrees to pay herein is or are less than what the buyer owes under the buyer representation agreement, then buyer shall be responsible for paying the remaining balance to the buyer's brokerage. For clarity, unless expressly otherwise stated, seller is responsible for paying any and all amounts due to seller's listing realtor. In the event that seller is not receiving any cash proceeds at closing, seller remains obligated to fulfill the payment by other means. Both buyer and seller confirm that they have not engaged real estate agent or brokerage in connection with this real estate transaction other than those referenced in this contract or in the information pages attached here to it. So we're pretty clear on what it says. How that would be interpreted in a court, I have no idea. This is a brand new contract. The verbiage is different. It wasn't written like that in the old contract, so it's relatively new. So we don't know where that might go. Section 9, I would just say, and I always say this, always go to the contract. If you're not sure where you are in a situation, read the contract. The contract always tells you. When agents call me, the first thing I will say with a problem, the first thing I always say is, what does the contract say? Let's go see what the contract says. And that's our agreement. This is our written agreement that all parties signed off on, and we have to live by this. So consequently, what we have right now is a situation here that we have agreed that the seller will pay X number if they agree to that. Buyer then is obligated to pay the difference if there is any. And that's how this is stated. So legally, this is the contract and this is how it is put together, and how it would be enforced, I have no idea on that yet. Section 9, seller certification, they only fix a minor grammatical update to improve clarity. A yes, no, change to has or has not. Those are, as you go through here, they've just changed it throughout. So you've got is and is not and has or hasn't. So they've just changed those words. It's all basically the same thing. They just clarified the verbiage. When you get into section 10, which is the homeowner association, formerly HOA. So now they're not calling it HOA anymore. They are calling it the homeowners association. So they're changing HOA to association. They've added requirement to disclose any secondary association fees, added requirement to disclose capital contribution required at closing paid by buyer, and updated the time frame for providing association contact info from 14 to 20 days. So whenever you go through this and you're looking at this whole section on condominiums, and it's not just condos, it could be patio homes, it could be planned unit developments, properties that have any kind of an association fee at all needs to be covered here. And this is where that everything would be referenced. If you are writing this contract to purchase and it gets accepted, I first of all know what you're reading here. If you don't know what you're reading, please let's go to a class on just how to write a condo section, which I've given and will continue to give again. but there's a lot of stipulations in here that people are missing. Go through these item by item and make sure that as you are requesting information from the listing agent or the HOA, that you're asking for everything they have listed there. That fulfills your contract. If you do not get everything that is listed in the requirements, then you have not fulfilled this contract, and you could put yourself and your client at jeopardy. So they have added the secondary association fees, and I'm trying to figure out where that is. Okay, it's in that from like 208, or I'm sorry, 209 is where they put the capital contribution. That was never there before. And it also was never in Kentucky. I don't think it still is, because I just did one. And I don't think that that's listed in Kentucky either, Jeff.
It's not.
So the capital contribution could be usually $500 to $1,000, sometimes more, but typically 500 to 1,000. But you need to check on that to make sure what that is if they do have to pay a capital contribution, and that's usually paid by the buyer. Let's see. And then the next is unknown and subject to buyer's verification and approval within the disapproval period, and seller certifies that the current association fees are, and you may have more than one association fee. You can have, I'm going to reference Triple Crown because that's in Kentucky. That's mostly where I work, but they have in some of the sections 3 different association fees. I just closed one that had quarterly, yearly, and there was another fee that came into play as well. So there were 3 different fees on that particular. It was a patio home. It wasn't even a condo. So there were 3 particular fees that it was associated with that property. So the best way to do that, whenever I list a condo from the listing end of it,
Yeah.
is to get a copy of the bill and to see exactly what they're paying. And they should have that available to them. Also call the HOA and talk to them. Same as a buyer's representative. If you're representing the buyer and you feel like you have information that may or may not be up to date, call them. I have a condo I'm selling for the second time. This is kind of crazy. In 2 months, because they walked away from the first deal, came back, bought it again. So now we're back in contract on the same condo again. And so today I called the HOA, and I'm going to find out if there's been any changes, because there could have been in 30 days. We don't know what happens in those meetings as they go forward. And there could have been maybe an assessment or something that popped up during that period of time. So whenever you're doing condos, it's critical that you go through this, you know exactly what this says, and I would make a list. I would make my own list of everything that is listed here that is required. And as I get those documents in, check them off. One of the things that is really important here, I'm going to just call it out, is having minutes of their meetings. I believe it asks for 2 years. So it's really, really important to get this. Most of the time you are not going to get those unless you specifically ask for them. If there's any issues in that condo association, that's where you're going to find out. If it's a potential assessment that hasn't popped up yet, it's probably not going to show up in financials, but it will come up in the meeting. So as you read those minutes of those meetings is when you're going to find out if there's anything awry, typically, that hasn't been, voted on or validated yet. So that would be a good place to go for those. So that's section 10, and that's the association. Any questions on that? William, what about you? Any questions? Okay. All right. You have to be very careful with condos. A lot of times too, I'm getting really involved in this right now, but I think it's important because I think it's a place that we really need to pay extra attention. But some condos most condos only allow a certain percentage to be allowed to be rented. And they have very specific requirements on those. So you may be selling to an investor and then they get the condo and realize they can't rent it out. So you have to be very careful on every single detail of a condo. Why are they buying it? Are they going to live in it? Are they going to lease it? Sometimes there are exceptions for family members that might want to lease a property in a condo association. So know all of those because you have to be very, very careful, again, to protect your client and to protect yourself.
And also, there's some kind of associations that only allow so much percentage of FHA or VA. or-
Very true.
And I personally find it that they shouldn't discriminate against VA loans. I can see FHA loans, but VA loans, even though they're government loans, they shouldn't discriminate. They shouldn't include those in their discriminate. Well, I call it discrimination, but in their bylaws. You know what I mean?
Right.
Because I've written VA loans that were $500,000-$600,000 loans that the only reason why they went because they better. So they could have been
Right.
conventional,
They
but,
could have,
you know,
yeah.
they work, they service our country. You know what I mean? And that's the reason why they went VA. It's not because they have enough money to put down for down payment.
Right.
You know what I mean?
They chose to use their benefits.
Yeah, exactly. But yeah, so a lot of times the associations will just write the bylaws like as such, to like only 30% be FHA VA.
Yeah, well, and some condominium associations are not approved for
Yeah,
FHA or
exactly.
VA. So whenever you're getting ready to write an offer, you need to make sure that that is a property that is approved. Now, some lenders also will pull out one unit, approve that unit to be sold. So it's a little more complicated. It used to be that, as Jeff,
It was a
been,
blank.
it was just a blanket for the entire community. It still is a blanket for many of the communities, but some of them have individual units that can be approved. And it's not really about the unit, it's about the lender who's doing the deal and whether they can get it approved for you. If it isn't able to be approved, they can usually do that within a couple of days.
Yeah.
It doesn't take a long time. But it's something whenever we're doing our loans on condos or anything that's HOA, we need to check on this, or association as they now call it. Section 11 talks about maintenance and it added requirement for the property to be left in broom swept condition at closing, which means just exactly what it says. That doesn't mean a deep clean necessarily. It just means broom swept. So if you can go in there and the floors are clean, I guess that's what it's saying. Clean up those floors with that broom and you are good to go. Basically, a unit should be left clean, but a lot of times they're not. Many times things are left behind and that can become an issue. So do your walkthrough prior to their final walkthrough and make sure what's there. I did a walkthrough a couple of weeks ago on a listing that I had, and the seller had not moved out a bunch of corrugated boxes that had been left there from a move. Somebody's move at some time. And it was as they stuck them all together, it was a substantial amount of boxes. So we had to get those moved last minute because they had taken them out and it was scurrying around, getting somebody to come pick those up and getting them out and paying for them and having someone pay for them, which the seller did. And it happened fine. It worked out okay, but it was that last minute rush to the finish line to get everything completely finished. So I would say at some point during that transition, when the seller's moving out and before the buyer does their final, I would, and sometimes it's only a day, try to get in there and to see how it looks to make sure everything looks okay. Do,
I'm here for buyers to ask for sellers to offer. The proposal, is that normal?
no, that's not typical. Is it? I mean, you moved here from out of state, as did I. So was, yeah, and I don't think there's anything wrong with that. I mean, that's a contingency that we could certainly add should we choose to do that. It's not typical. I don't think I've ever seen it on any contract I've ever written or accepted. However, it could be written in. I think that our market here is so brisk right now, and you know, we just need to do the best we can for the buyers that want to really accept that property. If it's really, really important to them, and they would not buy the house because it wasn't deep clean, yeah, write it in. But right now, we're still going into multiples on a lot of properties. We're still in very competitive market, highly, highly competitive, one of the most competitive markets in the country right now. So whether you would want to do that or not would be questionable. As time goes on and market starts to shift and even out, then that might be something you might want to consider. I'm not saying don't do it. I'm just saying it's just another added layer of aggravation to the seller and the buyer and to the agents.
Definitely wouldn't want my buyer to move out because they asked for conversation out there.
Yeah, I mean, but they won't ask typically here. You know, we have customs in certain areas, and those customs are not laws by any means. They're just things that we would add in as a something into an offer or whatever. However, that's not typical. So if you write that in, probably the other agent's going to go, well, who is this person and why did they do that? When I first moved here, I moved from Connecticut. I sold real estate in Connecticut, and there everybody moved on the day of closing, which is typically what we have now, right? Now almost everybody moves on the day of closing. However, in Kentucky, when I took my license there, they had 30 days to move out. Now everybody thought it was a law. It was never a law, ever. It was just a delayed occupancy is really all that it was. But everybody moved 30 days later. That was just how you wrote the offer for 30 days rent free.
Rent free, you could move out, and then you couldn't even like inspect the property until they were gone.
And a lot of things could happen during that period of time. It didn't. I mean, I sold over 1,000 houses over there and I never really had any issues with it. One time we had a buyer that did not do a walkthrough, waived it. And anytime they don't want to do a final walkthrough or anything they don't want to do, you think they should make them sign off that it's their choice, they're waiving it. You have recommended they do it.
Right.
And so this was in that crazy period of time when a lot of real estate drama was happening, foreclosures, etc. And it was also a time when copper was really expensive and very important to people. So this house closed in the afternoon, but they did not do the walkthrough. They waived the walkthrough. They would not do the walkthrough. They didn't have time. They had to stay at work. So they get to the house after the walkthrough. Guess what? Every pipe. So walkthroughs are really important. And walkthroughs just prior to the closing are critical. And the reason I say that is if it's especially during weather when we're not used to, you know, like today, everything's probably not going to change from yesterday. But if it's cold weather, if it's sub-zero weather, if it's excruciatingly hot, things can happen. Yeah, so you need to go in and check that. Things happen overnight. We had a walkthrough last year on a new rehab, been totally rehabbed, everything. And so they did like an early walkthrough, like earlier in the week. The agent, for some reason, just decided, you know what, I'm going to take one last walkthrough through there. And the water heater had burst and had dumped all the water in the basement. And this is an hour before closing. So, and a few days late before it was fine. So, you know, just pay particular attention to those. And we got all that from just being broom swept. How about that? A lot to talk about from broom swept to what could happen, right? 16 is property survey. This computer and I are not getting along well. It's section 16. Okay, so added A after reference to section 15 for clarity. After section 15, but it's saying it's section 16, so. Okay, well, let's just read through the property survey. Buyer acknowledges that it is the buyer's responsibility to confirm the location of the boundary lines and or to confirm the location of the improvements upon the real estate relative to such boundary lines, setback lines, and or easements. Buyer at buyer's expense shall obtain any survey of the real estate desired by buyer and or required by buyer's lender. If buyer desires for buyer's obligations under this contract to be contingent upon buyer's satisfactory review of evidence of survey, buyer must complete any desired survey and proceed in accordance with the timelines and process stated in section 15 above, so 15A above. Any survey evidence required by lender is not subject to buyer's inspection contingency and may still impact lender's time and conditions to lend. So if we go up to 15A, going. Having trouble finding 15A. 314. So in accordance with buyer's above election, buyer shall have a period of blank calendar days for the inspection period on the day following the contract acceptance date. So if they want to do a survey, that has to be within the same time frame as the inspection period in Ohio. You and I are double duty here. Is that Ohio or Kentucky? This is Ohio. It probably is close to the same in Ohio, in Kentucky. I believe it probably would be. Now, if they want a survey, should you recommend a survey?
I would say if there's a-
If it's under certain conditions.
if it's like acres and acres.
You know, it's interesting how they've changed because lenders used to always require what they called just a site survey. So basically, they would just look and make sure that the lot lines were effective with the home or property, whatever it was, usually like in a subdivision or something like that. So that was normal. They really aren't doing that more that I know of. Maybe some lenders are requiring it, none that I know of.
So you can go on you can get on RPR and run RPR, and the last page of the RPR will give you a boundary survey.
It does.
Indicates pretty accurate.
It is.
So
Yeah, that's true.
If there was something irregular about that, that's when I would bring it to their attention.
Right, but as agents, it's our duty to actually check those things to see if there looks anything precarious. So something to think about. I would always recommend a survey, like you said, on acreage, because with acreage, you really are, most of the acreage that has been platted was done many years ago, probably maybe even as early as 20s, 30s. And whenever you read those deeds, they're really interesting because they talk about go to the tree that is 10 feet tall and has green leaves. I mean, basically that generic. So for me to go out and try to figure out where that lot line is, we would never be able to do it. So it's, I would say, imperative on any kind of rural properties that have not been surveyed recently to get that done because they don't know exactly maybe where those lot lines are.
Yeah, and then also, you know, worried about like easements and like just passageways that like people have used for over 20 years. It's an automatic easement. You go back a real estate law. You know what I mean? So it's like.
So then it becomes a question, is it an easement
Yeah.
or has it been taken?
Yeah.
So it's, and they do show up. We had a property that one of the agents had here that was closing. And prior to closing, they realized that there was an easement, and I don't know the exact particulars because it wasn't my deal, but I did see the plat, but there was an easement that went kind of right through the middle of the backyard. So when they tried to figure out how they could deal with that in term, because it was right in the yard, right in their yard. And it was an easement that really they were using that wasn't their land. So they were trying to figure out how to get that land attached to their property. They made offers. I mean, it just turned into a big deal. But the agent was amazing and astute enough to find that out prior to closing. The deal did not work out. It went down. But, that's the good news is better have a deal go down than a lawsuit later,
Yeah.
right? So know what you're selling. It's really important. Pull those whenever we're writing purchase contracts, and I think we talked about this because you've been in all my classes, William. I appreciate you so much. Thank you. You all and Jeff, you guys both show up so much. It will make you amazing agents, not because I'm teaching them, but because we're going over the information again and again together. And the only way that we ever really know these contracts is to do it over and over and over again. And finally, you will kind of know what they say. At times, though, I still read them. I mean, I may be able to paraphrase them to you, but typically, if I'm with you, I'm going to go over the details of every paragraph with you so you understand what you're signing. So thank you for that, both of you. So any other questions or comments on property survey? No? Okay, section 17. This is my favorite. Because all of a sudden somebody decided that if you wanted to walk away for insurance on the last contract that we had through our MLS, you really did not have to provide anything stating that the insurance was too high, not effective for that property, and they had, according to the termination that we had, just walk away. Just say, you know what? We don't like our insurance, we're going to walk away. That's the way it was written, typically. Really, I mean, that was really what it said. Well, it worked until you had to go to court, and the judge did not look at it the same way that the MLS did. So we had a client that did go to court over that particular section because they canceled on the reason of not liking the insurance, that the whatever the terms were, and they walked away from the deal, and the seller refused to give the earnest money back. So the buyer said, well, you know what? I'm not going to wait 2 years, which you do have to wait 2 years to get your earnest money back in Ohio if everyone does not agree on giving the earnest money back. And she did not want to wait 2 years to get that money back. So she took them to small claims court. And guess what? She lost. So the seller actually got the money as they wished. Although, according to our contract, we adhered to the contract 100%. Exactly. Because you don't have to, at that time, we didn't have to give them anything. We did not have to say, here is the documentation stating that it's too high, can't be insured, whatever. So whenever we look at the property insurance verification contingency, would one of you like to read that for me, please? William, you are elected. You are a great reader. We appreciate you.
Buyer acknowledges that it is buyer's sole responsibility in inquiries to confirm availability and cost of any and all policies of insurance reasonably desired by buyer and or required by buyer's lender, including but not limited to hazard, flood, and personal property insurance. So it's important. The buyers of buyer's own understanding of insurance. Buyers will have blank calendar days and verification period. Beginning the day following the contract acceptance date to confirm that such insurance policy is or are available and that the cost is reasonably acceptable to buyer and buyer. The buyer cannot obtain such policy. So if the cost is not consistent with market rate, then buyers have the right to terminate this contract by providing written notification to seller along with proof of insurance and price or proof of pricing that is not consistent with market rates. Before the expiration of the insurance, the buyer cannot indicate a time frame in section 17, or does not timely deliver to seller a written notice of termination with prior proof. This contingency shall be waived.
Thank you. So that's exactly what we just talked about. And most changes come in contracts because there's been lawsuits. So whenever we see that, to me, that's a huge change because before they had to have no documentation, now they do have to have documentation. It's still vague to
It
me,
is big.
so as a judge, looking at this, how are they gonna define what is the right rate? Market rate, what is market rate? A market rate for one house in one area may not be the right market rate for a house in a different area. So how did they determine that? I don't know, but at least it's something. I think it's better than it was before. It's more well written, although it is still a little bit vague, in my opinion.
So, and then also to pivot off that, if the buyer had a lot of home losses in their previous home, and they look at Clue, which is
Correct.
yeah, they look at Clue and they get rated up. You know what I mean, on their new, because they've had so many like thefts, fire, burglaries, whatever, you know what I mean? Or questionable things. It's just like car insurance. If you drive your car and you crash your car 3 times and you get a DUI, you're gonna get rated up.
Or not have a license. The two.
Well, yeah, it is that, but I mean, if you go to buy homeowners insurance on a new property, Clue is like a reporting system for the Florida. And you get rated up for off Clue, you get rated up off Clue, you know, rather than the normal price would be, let's say, $1,200 a year for homeowners insurance. But since you're such a high risk for homeowners insurance, the ratio $2,400, you could easily go back and know how much are you paying. You're paying $1,200 and money towards $2,400, and you can get out that way. That's
Yeah, I would think so, the way this is written,
exactly. I mean, that's
because that's not a market rate,
but
that would be the market rate for that person,
for that
but it
person,
doesn't
but
define
it
this.
doesn't define that. You know what I mean? It doesn't. So how many days would you put in there?
For insurance, I mean, it doesn't take that long to get a bid on insurance.
So when I
I'd
was-
probably follow it the same as the inspection contingency.
Inspection report, okay.
Yeah,
when I was with the it might be approved, but
It is.
past claims.
Yes.
filed, and if there was something that happened previously at their property that wasn't disclosed, and they out to like the information flooded 5 years ago, they before the term. Maybe something that the current owner would not discuss to deal with. So where if there's a way eventually or can buy your back.
I think that that's not covered here and questionable.
It wouldn't be, it would have to disclose it because they in the house when
They don't have to disclose anything they don't know about.
Right.
when they were
Obviously.
Insurance company would,
Yeah, but they,
now it's knowledge that's been given to the buyer that's buying the house that the tree fell on. So, turns out it won't 6 years ago.
they would go back to condition. If they remove the tree.
And it was
restore
repaired.
condition, the current seller doesn't have to disclose.
If they don't know about it. I mean, if it happened and even if it's repaired and they knew,
They don't disclose it. It is property. Right?
Right, yeah, they wouldn't have to disclose it. But now it's supposed to be brought up. That because of the
Mhm.
They're buying it as-
I've never seen that happen. I mean, I think that going into the clue report would probably be up to the insurance company to do that and to bring that up with the buyer. I don't think it would show. Yeah, I mean, even I know we're mixing up a little bit because of Ohio, Kentucky, but Ohio does not remove like the property disclosure reports, those are left up. In Kentucky, when a property closes, they're gone. You will never see them again. They removed those from MLS, gone. So if you want to go back and see the previous one, let's say it sold a year ago. You can't get it. It's gone. It's gone forever. So, well, there was a reason they did that, and it was to protect, I guess, the new buyer. I don't know. Anyway, it doesn't make any sense to me. But the good news is that in Ohio, you can still access those. So a title insurance contingency, they changed the seller contribution from 300 to 500. And that would be section 20. And seller shall pay an amount of 500 towards the purchase price is line 417, section C. If that's what you choose to do. They offer you choices, okay? So the buyer can buy their own title insurance. The buyer shall later determine whether to purchase an owner's policy of title. I sometimes mark that later they're going to choose it because they may want to look at title pricing, et cetera, and talk to title. Because if they say they don't want to buy title insurance, I always recommend they talk to title before they say no, because I think everybody needs title insurance. Seller C, 417, seller shall pay an amount of 500 towards the purchase price. D, seller shall pay the entire cost of the standard owner's policy of title insurance of finance. So you have 4 different choices. Title insurance is critical, I think, especially in this day and time. I highly recommend it. So again, if it's something that your buyer's saying, oh, I don't know if I really know that or need that, make sure that they do talk to title before they make that decision 100%. And they usually have up to 30 days after closing to go ahead and purchase that.
So what do you normally check there? I mean, you check A, right? Buyer likes to purchase the policy at expense, right? If I'm writing a contract, if I'm writing a purchase contract, it's A, right?
Yeah, but it's A or C. A lot of times it's going to be C because you're asking the seller to contribute 500. So, I mean, it's up to the offer you're writing. If you're writing an over ask offer, competing with everybody else, then you got to be careful what you choose. It would probably be A. But in a normal market, like a balanced market, you might ask for C. Right now, we're not in a balanced market. Some areas are, and parts of Kentucky are definitely in a balanced market, Jeff. In northern Kentucky, most of Cincinnati is in still very much heavily weighted towards selling, the seller's market. But we are starting to see segments of the city that are buyer's markets. So whenever you're looking at that and you're trying to figure out, is it something I could or should ask for? It really does depend too on what's happening around that property. But a lot of times I will check B if they can't make up their mind exactly what they want to do, whether they want title insurance at that time or not. I'm not ever going to just say, no, you can't walk away and not buy it. You need to talk to title before you make that decision. See, they don't even give them that option here. What they say is they elect to purchase it on their own, at their own expense. They shall later determine, or they shall pay an amount. Seller shall pay 500, or seller shall pay all of it. So they don't even give them the chance to say they elect not to buy title, which is interesting because that's also their option. In which case they say they don't want it, then I would mark B and say, you really need to talk to somebody first. Section 23 is conveyance and closing. Which is line 473. And what they've done is added capital contribution clarification for alignment with section 10. So where is that here? Section, they gave us a section, but not the line. I guess that it must, do you guys see it? It must have just been added in the language. And that they are adding the capital contribution? So pay particular attention about those. We go through the contracts from now on because since capital contribution has been added, that the buyer will pay it.
477.
Thank you. Yeah, it's just clarifying that they, again, that it, that at closing, buyer shall be responsible for any association capital contribution fees. It's a good thing they added that because I think that is something a lot of buyers will ask about, whether they would have to pay it or not. Section 25 is agency disclosure. And they're clarifying that disclosure is an integral part of this contract. So 511, which is line 511, which is section 25, buyer and seller acknowledge having reviewed the state mandated agency disclosure statement, which is an integral part of the contract. So I'm glad that they added that.
That pretty much holds their feet to the seller's feet to the fire, because it's like they're acknowledging that they wrote it.
I'm confused. Buyer and seller acknowledge having reviewed the state mandated agency disclosure statement.
Yeah, so they're acknowledging that the seller, what the seller put in the disclosure statement.
Agency, who's representing whom?
Oh,
Okay,
oh, agency, I thought. Oh,
I know you're on property,
I was on
right?
property.
Yes, okay. All right, so agency disclosure again is who we're representing, and are we representing the buyer or the seller? And that's going to be defined there, and it does become part of this contract now. It was never stated like that before.
Oh, sorry, it was
No
I was
worries.
on property.
Well, we've been talking about property all along, and now we hop over to agency.
Yeah.
So I understand completely. But on the agency, you have to be very careful with how you write agency and when you write it. You should always write your agency. You should always give them the disclosure prior to writing the offer so that they can review it. Yes, you have to have agency when you're writing this.
Yeah, but before you get your buyer broker. Well.
You should write agency at the same time if you can.
Okay.
In Kentucky, you have, it's a little different.
Okay. Okay.
I know, but
It covers you so much better than I.
it does, but they're not the same. So you have to be really careful with that. I live by California rules, Mrs. Hunt, because they're way over the top. You live by their rules, and I'm just kidding. I don't. I live by whatever state we're in. That's what we have to live by. And right now we're talking about Ohio. No worries, because you and I both still gravitate to the south side of the river. So agency disclosure number section 28, sole contract, replaced fax or internet with electronic. That's good. Somebody asked me to fax something a couple weeks ago, and I'm like, I don't even know how to fax anymore. So it's been changed from fax to electronic. Section 32 about indemnity, let's get to that. They expanded the hold harmless language for greater protection. Now, don't depend on this because this does not mean somebody cannot sue you. They're stating in here that they won't, but it doesn't mean they can't. So read through this, know what it says, and also know that if somebody does decide to go after you, they absolutely can and they will. That's why you have E&O insurance. Do you want to, should we read through that together? Or are we good? Indemnity is basically a hold harmless for everyone involved in the transaction. And at the same time, it really doesn't hold up. So let's look at that as a reminder to be careful with everything we do. Because whenever we're saying they're holding us harmless, they don't necessarily have to. Section 37 is buyer certification. In section 37, buyer certification, buyer certifies and warrants that the signatories below has or have full authority to enter into this agreement, and that any and all additional signatories, spouse or otherwise, who are necessary in order to purchase the property or obtain lender financing for the real estate purchase have expressly agreed to sign such required purchase and or financing documents. Dower or other spousal rights may require signature of spouse, even if spouse is not on the loan or title. D, list all persons or entities, including yourself, who shall have an ownership interest in the real estate, which would be dower ownership rights and or names of the individuals whose signatures are necessary to obtain financing and or purchase the real estate. In the event, in line 584, in the event of power of attorney, trust, corporation, limited liability company, inheritance, or other right to transfer documentation of authority to purchase the real estate shall be provided to the title company settlement agent upon request. I would say if you're writing for a trust, get a copy of their agreement. If you're writing for an LLC, get a copy of their agreement and make sure that they have the ability to sign. We've run into a couple of times when we had a group of properties being sold, and their document never said who could sign. Did not identify anybody who could sign. So we had a deal we really did not know what to do with because nobody was qualified to sign the documents. And that was a whole thing. So just be careful to get that. Also, a trust is a trust. Do you know what a trust is? A trust is an entity just like an individual. So as Susan Ash selling or buying, I'm Susan Ash. The Susan Ash Trust is not me. I might be the trustee of that trust, but it isn't me. So whoever is a signator for that trust would be the person who would be required to sign all of the documents. And we just ran into one last week and it was interesting. It was a divorce and a trust going through foreclosure. So it got to be really, really interesting. Yeah, it was dual agency. And at the time, listing the property, unaware of some of the aspects of the deal. So always we've heard, and you will be taught in real estate school, 1 to buy and 2 to sell. How many times have we heard that? 1 signature to buy and 2 to sell. This is not what this says. Now it says everybody has to sign or that they're agreeing to sign. So if you're going through a divorce and they agree to sign and choose not to sign, good luck with that. So I would say if their signatures are required, go ahead and get this at the time that you're doing any kind of an offer. It's still dower. It's still dower rights. So the one we closed last week was dower, but then it became a trust. It was always a trust and nobody knew. And I was going through the documents and I said, oh, wait. And I called the title and I said, well, we don't have to worry about the other person showing up because this is a trust. The trustee is yada, 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 and the trustee is coming to sign. So guess what? It was sold.
Yeah.
And the other party who thought they had an attachment to it couldn't do anything. So just be careful when you're selling properties that you know what you're selling. If it's individuals, it's not that difficult. Unless they're in process of divorce, then it becomes something different. And you need to make sure that they do have a release of dower if they're not divorced yet. If they are, and if there is a decree already, you can go by what the decree says. But always don't interpret it and have the attorneys tell you that, whatever it says. So that's it. It's just updated to clarify section 38 that all owners and spouses must sign closing docs. So that's where we are. What kind of questions, comments, anything that you want to talk about here today? William, thank you. How many times have you gone through this? Just for everybody, because this is going to be a video that's put out for our office. or more, maybe 4 or 5, probably. Oh, the exclusive right to sell. Mhm. Yeah, it takes time. I mean, this is a very long, involved, intense contract, and it's becoming more intense as time goes on. Every time we get a new contract that's longer, um, it has more defined information, which is not a bad thing as long as it's clear. Sometimes it clarifies a lot of different things that we've been dealing with. The one thing that still is a problem, the way that it's written, is the earnest money. I will say that until they change it. But at any rate, it does clarify. But even with that, there's something new in here all the time. If you've been an agent for 20 years, chances are you may know that contract better than the older agents do, or more, not older necessarily, more experienced because you spent time with it. You spent time with the new contract. You know what it says. You know the lines. You know where things are, and that's awesome. And I would implore anyone who ever intends on writing a contract now or in the near future, which I hope you do because that's why we're in this business, is to write contracts. Know what you are putting in front of your client to have them sign. If you don't know what you're putting in front of them and asking them to sign it intimately, if you don't know it intimately, you're not doing your job. I will just say that. So know this contract. And I would say, please come to contract classes. Thank you for coming. Jeff, thank you. Because you guys rock, because you always show up, and I appreciate that more. My pleasure. My pleasure.